So welcome. What is the topic here today? Titling your assets, critical do's and don'ts, what you need to know. For those of you who haven't subscribed to our Gilfix Law YouTube channel for more. But it sounds really boring to titling assets. I get that. But it's actually so important. And mistakes in titling assets can cost your family tens of thousands or hundreds of thousands of dollars, can cause all sorts of problems and trigger unnecessary tax issues. And it can mean assets go where you don't want them to go, or that they get stuck in court. So this is absolutely crucial. That's what we're going to go through here today. How to title assets. Let's go through what we're going to talk about. So one, how you need to title your home and or any other real estate, your non-retirement investments and bank accounts and other entities you might own pieces of, how title for retirement assets works. It's a little bit different than non-retirement assets. Life insurance, similar. I'm going to talk about that briefly. How to ensure your assets are properly managed if you can't manage them for yourself, if you're ever sick or incapacitated. The title of the assets can have a huge impact on that. We'll talk about that, and we'll talk about 5 steps that you really need to take and what you can do to be sure that everything is up to date and that you don't have massive problems or your family doesn't have massive problems. I always have to point out this is for educational purposes only. It is not official legal advice, doesn't create an attorney-client relationship. For those of you who already work with us, we already have this, but this discussion doesn't on its own. We always need to meet with you directly to understand your issues, to give actual legal advice. So what are we talking about here? So those of you who don't know our firm, by the way, Gilfix and the Pole, I think everybody here probably knows us. We've been around for over 40 years in Palo Alto, worked with thousands of families. But you guys, most of you watching here know us already, but if you share this with friends and family, just a little bit about us. Let's talk about real estate, how to title real estate. And here's some questions I hear all the time. How should I title my real estate? Should I put it in joint tenancy with right of survivorship? Should I add my child to title? Couldn't that make things easier? What about these transfer on death deeds? Or maybe I should just put it in my living trust. The do's and don'ts of titling real estate. These are good questions, and there are very clear answers to each of them. So first, let's address joint tenancy with right of survivorship. There's different structures for this. We do not recommend that you title your home in joint tenancy. If it's a right of survivorship, if you have a piece of property as a joint tenant with someone else with a right of survivorship, what that means is if you pass away first, they get 100% of the property. It doesn't go to your heirs, and maybe you have the same heirs, but you lose everything. It's kind of a game of chicken. Who kicks the bucket first? They win and they get everything. So that's problematic. You can manage the property if you're incapacitated. If it's joint tenancy or not in a living trust, there's not a real clear line of who's authorized to work with the county to deal with title issues, to deal with the real estate, with issues related to owning real estate. So if it's not in a living trust, if it's just in joint tenancy, there's no clear line of succession if something happens to you. If it's in joint tenancy, when the second person in joint tenancy passes away, there's nothing else to direct where the house goes or where the property goes. So it's stuck in probate. It's stuck in the court system. It can cost tens of thousands of dollars just for one piece of property, by the way. Probate fees can be tens of thousands of dollars. It can take years before it goes to anyone you care about. Property tax issues. If you're not married and the property goes from one person to another in joint tenancy, there could be a full reassessment of property taxes, all sorts of issues. And of course, as I mentioned before, exposure to probate. And if something's exposed to probate, that can open up a whole nother can of worms, or there could be a state reimbursement claim if you receive certain types of public benefits during your life. So we don't recommend joint tenancy. There's other nuances here that I'm not going to get into, but generally speaking, joint tenancy is very problematic. Another question we get, the do's and don'ts of titling real estate. Should I add my child to the title for my property? Well, I have one son. Why don't I just add him to title? Let's just do that. Simple. Or maybe I make him the beneficiary if something happens to me. Well, if you add a child to title right now, don't do that. You could face an immediate property tax increase. Prop 19 is now law. I'm going to talk about that in a little bit, but it means that if you add a child to title or transfer any share of your home without working with us, without doing it properly, whatever you transfer could be fully reassessed at fair market value. So if you've owned a house for many years, for 10, 20, 30 years, your property taxes are probably much lower than they would be if you bought the house today, right? Because Prop 13 keeps your property taxes low. If you add a child to title, That's a transfer of property, and there are some limited protections under Prop 19, but if your child doesn't live there, it could be a full reassessment of whatever portion you transfer to your child. In plain English, that means property taxes could go up by $5, $10, $15, $20,000 a year at the time you do it if you don't do it the proper way. So don't do that. You lose the stepped up basis. So if you add a child to title for, let's say, 30% or 50%, whatever portion you've added them to title for, that's a completed gift. It is there, they own it. So when you pass away, that doesn't get a stepped up basis, meaning if the child ever sells in the future, they could have huge capital gains tax issues. Whereas if it's in your name and it goes to your child after you pass away, they get the benefit of a full step up in cost basis. So other steps we can take to prevent that property tax increase that I'll talk about in just a moment. Exposure to liability. If you add your child or anybody else to title for your home, if they're sued, if they go bankrupt, if they are facing huge debts, that portion of the house is exposed to creditors. So if you add someone else to title, you are opening up their share to bad third parties coming after it. They can force a sale of your home if you can't pay them off. All sorts of issues. And if you add your child to title and don't do anything with your share, well, your shares could still be stuck in probate. It could still be stuck in the court system for years. So what we generally recommend is, well, you probably know this if you worked with us before, but you need to title your home and real estate in your living trust. And that is our presumptive recommendation for the vast majority of situations. No property tax issues while you're living. If you become incapacitated, by having a property or properties in your living trust, your successor trustees can pretty seamlessly step in to manage the property. And when it's in your trust, when someone is incapacitated or just doesn't want to manage anymore, we can actually record an update to the deed with the county where we say, hey, there's a new trustee in charge. It doesn't change ownership, but it changes who's in charge of it. And it's pretty seamless. It's something we can actually file with the county to give your trusted backup trustee the ability to step in pretty seamlessly to deal with issues around real estate and to manage it for you. Of course, when you kick the bucket, when you're gone, if you have it in a living trust, it's not exposed to probate. So it doesn't go through the California court system. It stays private through a trust administration process, which is much cheaper than a probate. Still needs to be done properly. And of course, if it's in your living trust, we can do much more sophisticated things about where the house goes after you're gone. For example, if you have kids, you want to protect the value of your home from lawsuits and divorce and future estate taxes, you can direct it to family protection trust, generically known as dynasty trust, for your child or children. If you have a child with special needs or a disability, you can direct it to a special needs trust. So having a living trust ensures that you can keep the beneficiary plan up to date, that you don't need to constantly change things. Once it's in the trust, anytime you update your trust, it will redirect where the house goes after you're gone. So have it in your living trust. Now, there is some nuance here. We have to be aware of Prop 19. If you watch our talks, you know we hammer this, but it's something that I think maybe 5% of families who need to understand this actually do. You are ahead of the game. Prop 19, relatively new law, became law in 2021 in California. And it means that when properties pass from you to your kids or nieces and nephews or grandkids or wherever it goes, there could be a massive reassessment of property taxes. We've seen cases where property taxes can go up 10 times, like from $2,500 a year to $25,000 a year, or even more. If you've held real estate for a long time, we need to be aware of this. Even for your primary residence, there are only limited protections for property tax increases when it goes from parent to child, even if the child lives in your house after you're gone. So this is a case where we actually might move it out of your living trust and utilize something we call the Dynasty LLC process. It would ensure that everything is done properly, but we can avoid those massive property tax increases. So we hammer this, but if you have appreciated real estate, talk to us about this. But generally speaking, it should be in your living trust unless you're really worried about this property tax issue. And if you've owned real estate a long time, you should be. Let's talk about the do's and don'ts of investment accounts, non-retirement investment and bank accounts. How should these be titled? We hear, should I put them in a transfer on death account, or should I add my child to this account? Or should it be in my living trust? So I'm going to go through some of those questions. So generally speaking, for non-retirement investment, bank accounts, savings accounts, don't add a child to title. Maybe for a small account. If you have a side small account, you want your kid to have access to it, maybe you can add them to title for that. But keep in mind, the moment you add someone else to title for an account, they have full access to it. And if they are sued, it's exposed. If they have debts, it's exposed. If they go bankrupt, it's exposed. all sorts of risks we don't want you to take. It's also no longer part of your trust estate. If you add someone to the title for an account, when you pass away, it just becomes that person's property. There's really no ifs, ands, or buts. So I guess that it avoids probate, but there's no asset protection. If you created protective trust for your child or children or grandkids, it's not going to those protective trusts. It's just going to the person who's named on the account. Similarly, for transfer on death accounts, we have some clients who have come to us. They said, oh, I have this account. Well, I named the beneficiaries. When I pass away, it goes directly to these people. Doesn't allow for easy lifetime management. It's not in your trust, so your successor trustee can't really help. There's other ways I'll talk about how you can still get some help there, but it's very simplistic. If anything goes wrong, there's no backup plan. If it's a transfer on death account, well, it's only going to the person named there. You do all this work to create a living trust and have a thoughtful bequest plan. That's not going to be followed. It's only going to go where it's named there. And what if something happens to that person? If you created family protection trust, dynasty trust, or special needs trust, it's not going to those trusts. It's probably going to that person. So we don't recommend adding a child to the name of an account. We don't recommend transfer on death accounts, because you need to have comprehensive estate plan. There's so many reasons why you need that. And if you're watching here, Peace of Mind members, you have that. And if anyone in your circle doesn't have this yet, of course, they need to have that living trust set up. And the trust is really only effective if it's properly funded. So I've talked about real estate. Real estate needs to be retitled in the trust. That needs to be done via formal deed and some forms. But for non-retirement investment and bank accounts, they should be titled in your trust. This ensures that you're in charge of it as long as you can be. If something happens to you, your successor trustees can seamlessly step in. It ensures that when you pass away, you get that stepped up basis. If you add someone's name to an investment account and it just goes to them when you pass away, there will not be a full step up in cost basis, meaning capital gains taxes, if it's in your living trust, goes to your named beneficiaries or their trusts after you're gone. Full step up in cost basis, capital gains taxes are eliminated. If you do it wrong, your heirs might not get that. And it's also part of your comprehensive estate plan. So if it's in your living trust, all that work you do or that we do with you to create a sophisticated, well thought out plan with protective trusts for your kids, whether that's special needs trusts or dynasty trusts, if an account is in your living trust, hey, it's going to go through the trust where you want it to go. If it's not in your trust, we can face all sorts of issues. So, I know over time, sometimes you'll open a new account, you'll forget to put it in the trust. It's not a hugely challenging process to do that. So make sure your investment accounts, your non-retirement accounts are in your living trust. How do I retitle assets into my living trust? So you have an updated living trust, you just created it, your loved ones just created one, and you need to make sure titles are in properties and assets are in your living trust. Maybe you bought a new piece of property, maybe you have a new bank account or investment account. How do you put it into that living trust? Just a reminder for many of you here, but for real estate, it needs to be done very formally. You need to work with an expert attorney. We help you with this to make sure that you have a deed that goes from you as an individual or however it was titled before into your living trust. There are some tax forms that need to be filed with this. It has to be done right. Do not try this at home. You might inadvertently trigger a massive reassessment of property taxes. We want to avoid that. That's why we always handle this for our clients. Investment in bank accounts. You don't need lawyers involved there. And in fact, we're limited in how much we can help. We help many clients with this, but you really have to work directly with financial entities. So say you have accounts at Fidelity or Schwab and you have a living trust. Well, you would send them a copy of your certification of trust. So it's part of your trust packet. Whenever we update a living trust for you guys or for our clients, or whenever you create a new living trust, we have the living trust, and part of that packet is a certification of trust. It's like a 3-page summary of your trust that is notarized, and it is designed to be given to financial entities. It tells them what they need to know, but it doesn't tell them anything they don't need to know. So it proves to them that you have a trust. It shows who the trustees are, but it's not their business to know where everything's going after you're gone. You can keep that private from them, but they do need proof that you have a trust. You present that copy of the certification of trust. They send you hopefully DocuSign. When I retitled my own accounts, I was able to do it all over DocuSign. So that usually is a fairly straightforward process, at least for traditional investment savings and bank accounts. You contact the bank, say, hey, I want to make sure this is in the trust, send that certification of trust over, and either in person or hopefully via DocuSign, you just retitle them. It doesn't change tax reporting. It doesn't change the social security number connected to the accounts. It just makes sure that they are in your trust. So really an important step to take. So real estate, do it formally with a lawyer. Investment bank accounts, do it directly with banks or investment entities. Let's talk about retirement accounts. Retirement accounts and titling these. They are not titled in your trust. So this is IRAs, 401ks, Roth IRAs. We're not going to get into the details, but they can't be titled in your living trust. They have to be held by you individually. Sometimes for inherited IRAs, there are special trusts that can be set up. Not the focus here today, but retirement accounts, we don't really have the choice. We can't assign them to the living trust while you're living, but you have to make sure that your beneficiary designations are up to date because they are directed according to beneficiary designation pages. So we talk about transfer on death accounts. Those are sort of beneficiary designation options. But for retirement accounts, you need to make sure that your beneficiary designation pages, that those forms are always up to date. Now, how do you fill those out? You can simply say, okay, when I pass away, typically if you're married, you would leave it to your spouse. But if your spouse isn't around, you can leave it to your living trust. And then it's just distributed according to the terms of your trust. Now, that's one option. The good thing there is anytime you update your trust, you're updating the beneficiaries for your retirement accounts as well. Now, the downside is it takes a bit longer and there's some other logistical hurdles that have to be overcome if it's going to your living trust. It takes some time to go through the trust administration process, and there's some regulatory issues we have to be aware of. But broadly speaking, many of our clients choose to just simply name their living trusts as beneficiaries for their retirement accounts. But you can also, if you have, let's say you have two kids, and for one child, you set up a dynasty trust, the other child, you set up a special needs trust, you could simply name those trusts as beneficiaries of your retirement accounts. There's income tax issues to be aware of, but you absolutely can do that. So, or you can leave it directly to kids. So there's a lot of ways to do that. We have to be thoughtful and you have to update this regularly. Take a fresh look. There are horrible stories. I remember one in the Wall Street Journal a few years ago about this gentleman who passed away in his 80s and he had a multi-million-dollar retirement account. And he hadn't touched his beneficiary designation since he was like 28 years old when maybe it wasn't that long ago. Maybe it was like, because I think retirement accounts didn't exist 60 years ago, but it was something like the early 70s. He had set it up, or late 70s, and he had named his brother. And by the time he passed away, he wasn't even friends with his brother. They were estranged and he had kids of his own. But because he didn't name his kids as beneficiaries, the form governed it. It went to his brother. So don't let that happen, especially if it's been a long time since you looked at your retirement account beneficiary designations. Take a fresh look and make sure that the right people are named, usually your spouse, and then either your living trusts, your kids directly, or trusts for their benefit. How do you title LLCs, or if you maybe own a piece of an LLC or a partnership or other more sophisticated investments, maybe a piece of a business? Well, it's a little bit more complicated. So key, and I'll circle back to the importance of Schedule A's for other assets too, but you should list your ownership share on your trust Schedule A. I'll talk about trust Schedule A's in just a moment, and Schedule B and C. You can list it on the Schedule A. That shows your intent that these are titled in your living trust, but usually you have to work with the entity. Like if it's an LLC or a business partnership, you'd go to the entity or the attorney who helps set it up, and you'd say, hey, look, I just want to make sure that my shares within the entity are titled in my living trust. Those are typically allowed and should not cause any issues. Most LLCs or corporations allow people to transfer their personal shares into a living trust without any issues. Sometimes it's a little bit tricky. So we usually can't help directly with that. Sometimes we can, but usually you'd work with the entity itself that helped you set up the structure to do that. But very important that ownership shares of more complicated investment types are also titled in your living trust, or if you're unsure of how to do that, at least let's get it listed on your trust Schedule A, which is a list of what you intend to be in the trust, or Schedule B or C if it's separate property. I'll talk about that in a moment as well. By the way, if you have questions, feel free to enter them in the Q&A function. I'll get to some at the end. So please feel free to ask them. But right now, I know we're going through a lot here, but really important that all of your non-retirement assets be titled in your living trust. Now, life insurance. How do you title life insurance? Well, this is another exception. So retirement accounts can't really be titled in your living trust while you're around. But if you own life insurance, same issue. For many different regulatory issues, you cannot transfer ownership. You cannot typically transfer ownership of a life insurance policy into your living trust. Now, there are special trusts that can be set up to hold life insurance policies, ILITs, irrevocable life insurance trusts. Those are more sophisticated tax planning tools. So in those cases, you can have life insurance in a trust, and the trust would govern where it goes. But generally speaking, you can't. So kind of similar to retirement accounts, you have to make sure the beneficiary designations are up to date, because whatever that beneficiary designation says, that's where the life insurance policy is going to go. Doesn't matter if you've had 2 kids since then and you meant to add them, but you didn't when you set up the policy. Whatever is on that form will govern. And you can leave a life insurance policy to your living trust if you distributed according to the terms of the trust. But again, if you want to leave it more directly to your kids or beneficiaries, it's a quicker process, but you have to make sure it's up to date. So if you set up a dynasty trust, family protection trust for one child, a special needs trust for another, you absolutely can name those trusts as beneficiaries of the policy as well. So you need to make sure life insurance policies, it's less how they're titled, but more how the beneficiary designations are up to date. Asset title and who can manage your assets if you can't. Let's talk about who can step in for you to manage your assets and why title is important for all of this and the documents you need to have in place. So if you are incapacitated, if you are sick, if you can't manage things for yourself, if you face dementia or some other issue where you can no longer oversee your own assets, real property, non-retirement investments, they should be in your living trust. They should be retitled there. And if they are in your living trust, your successor trustee, the person or people who step in for you as trustee of your trust, they can pretty seamlessly take over management. You would send some documentation off to, if it's real estate, we can actually file an affidavit change of trustee where we don't change title for the home. We just let the county know, hey, a successor trustee stepped in. That gives the new trustee the ability to pretty seamlessly work with the county and deal with real estate issues. For non-retirement investments and savings accounts, you would let the financial institution know, say, hey, the primary account holder is incapacitated. Here's a doctor's note. I'm the successor trustee. Here's the trust. And you can generally step in and manage. Sometimes banks are a little difficult here, but I mean, banks are always difficult, right? I don't know how many times you guys have had to deal with different banks, but sometimes you go to one branch and they're great. The same bank, go to a different branch and it's like a nightmare. Anyway, the best we can do is having an asset in a living trust. And I can pretty seamlessly give someone access to manage your affairs, your financial affairs, if you can't do it. Now, retirement accounts, life insurance, and other assets that can't be in your living trust, that's where your durable power of attorney for finances is key. So whenever we set up that updated estate plan, if we ever helped you to update your living trust or set up a new plan, you know we always want to do a new living trust and a new durable power of attorney at the same time. And we generally want the same people named as backups in each of these. So your successor trustees, the same people named in your trust as backups should be those named in your power of attorney document as your backup agents, or as they're known in the document, attorneys in fact. Very confusing term. Don't worry about the terminology too much, but we want to make sure that both of these documents are up to date, because if an asset's not in your trust, well, it falls under your durable power of attorney for finances, and the person named there would also show a notice of incapacity from a doctor and the document showing that they're authorized to step in. We always want you to update these documents regularly. The older the document is, the less likely a bank or financial or government institution will follow it, whether it's a trust, but especially power of attorney documents. So you need to make sure they're up to date and the right people are named there. So for your financial life, your assets, if you can't manage them, real estate, non-retirement assets should be under the living trust. Your successor trustee can step in. Retirement accounts, life insurance, non-trust assets, your power of attorney governs that. So some planning tips for who can manage your assets if you can't. As I mentioned, your successor trustees in your living trust, the people named to step in there if you can't, should be consistent with the people named as your attorneys in fact, the backups in your power of attorney document. So anytime, sometimes we'll get a call from a client will say, oh, I want to change my backup trustees. I just want to add my brother Joe as the second backup. One, we always need to verify why you're doing it, make sure that it makes sense. But two, if you're doing that, we also need to make that change to your durable power of attorney document. We don't want Joe named as your first backup in your trust, but not in your power of attorney document, because some assets kind of fall in between trust and non-trust, and you don't want one person dealing with trust assets and another person dealing with non-trust assets. It gets very messy and complicated. You want one person in charge of all of that if you need that help. And you should revisit this every 3 to 5 years, or really anytime your situation changes. So every 3 to 5 years, meet with us. Let's go over it. Let's make sure it's up to date. You have the right people named. Let's talk it through. We've given many other talks on what a trustee is, how you choose a trustee, lots of implications there. We have a lot of clients with no kids. Maybe you don't have kids. You're not sure who to step in, who can step in after you. If you do have kids, are they able to do it? Do you trust them to manage your money? Some of our clients, it's a no-brainer. Other clients are like, I don't know. So We always recommend that you take a fresh look every 3 to 5 years, and speak with the people named in your living trust and in the power of attorney document. Make sure that they are willing and able to serve. We don't want you to name somebody who seems perfect, but they can't do it. They don't have the bandwidth or the availability to do it. And of course, we can help with all of this. Use your peace of mind members, use your peace of mind meeting with us. Let's revisit that every year. We can take a fresh look at that, or at least every couple of years. For non-peace of mind members, of course, anytime we can meet with you and go over these issues. What is a trust Schedule A? You're probably familiar with these, and Schedule B and C. So trust Schedule A, B, and C. This relates to title for your assets, but it's not determinative. So your trust schedules, Schedule A is typically community property assets. Schedule B is typically husband's separate property assets. Schedule C is wife's separate property assets. It's a list of assets intended to be in your living trust. Just because you add something to the trust Schedule A, B, or C doesn't make it part of your trust. It just shows you wanted it to be. And it serves a lot of purposes. One, it can be helpful for your successor trustee or family members to just know what you have. It's hard to know all the accounts that we hold. Over the years, I have some clients who've set up accounts at 6 different financial institutions. I myself had to consolidate a few years ago. I had stuff at like 6 different banks, some tiny accounts, but it can be really hard to track that. So Schedule A's, Schedule B, and C are a great way to just keep track of your non-retirement accounts. But it's also really important because I'll talk about the importance of formally titling assets in the trust. But if you don't formally title them, but at least on the Schedule A, well, we have evidence that you wanted it to be in your trust. And if something happens to you, we can at least use that evidence to go to court to often get a court order to put it in your trust, even after you pass away, or if you're incapacitated, to make it a little bit cleaner. So again, Schedule A is community property assets. Usually the majority of your assets are community property here in California. But if you came into the marriage with separate assets, or you inherited, you can still put those in. You should put those in your living trust, but it's really important for us to track those on the Schedule B for husband's separate property assets, or Schedule C, wife's separate property assets. Typically, the most common type of separate property assets are inheritance. So if you inherit, a couple $100,000 from a parent or grandparent, you should put that in a living trust account, but you can still keep track of it as your separate property account. If you're not married, well, it's just a Schedule A because it's just the trust assets. But critical though, just because you put it on the Schedule A does not make it part of your trust. You need to go, again, for real estate, we need to work with you to make sure it's properly titled in the trust via deeds. And if it's a bank or investment account, you need to go to the bank, the investment authority, and give them the copy of the certification of trust. Make sure it's transferred into your trust there with the bank or financial institution. And here's how to kind of think of it. If an asset's on the trust Schedule A or B or C, but not titled in the trust, that's potentially problematic. Yeah, it shows your intent that it's in the trust. It helps your trustees to find the assets, but they're not actually in the trust. We're gonna have to go to court to fix that if something happens to you. If it's titled in your trust, like real estate or your investment or savings accounts, if you worked with the institution or with the county, we've helped you with real estate. If it's in your trust there formally, but not on your Schedule A, B, or C, you're actually generally okay. So it's actually more important to update the title of the assets themselves than to update your Schedule A or B or C. Ideally, both are up to date all the time. But the first step, I would say, if you have a new asset that you haven't gotten around to retitling it yet, let's still at least add it to your trust Schedule A. If you're a Peace of Mind member, we update your schedules every year at no cost. It's part of our membership program. But we want to make sure that's up to date. But really crucial that you update title with the entities themselves as well. And a reminder, okay, so we've talked about title, the importance of real estate transferring into your living trust. So just a reminder, I know we hammer this, but if you own a home in California for many, many years, or if you own rental property, if it's gone up in value since you bought it, if the fair market value is a lot higher than the assessed value, remember the assessed value is kept low by Prop 13. So if you bought a house 20 or 30 years ago, the assessed value can go up 2% a year. The fair market value has probably gone up an average of 7 or 8% a year over the last few decades. So there's a big gap. If we don't think about Prop 19, there could be a massive reassessment of property taxes when it goes from you to your kids, grandkids, niece, nephew, or really anybody. And we can prevent this. So this is where there'd be sort of an exception to just simply keeping real estate in your living trust, where we use a dynasty LLC process. You talk to us about it, but here, just a visual reminder for Prop 19. And this is just an illustration of one house that's Worth, admittedly, I used a high valuation. I created this spreadsheet, but let's say you have a house with a fair market value of 3.3 million, aka a decent sized house in coastal Southern California or the Bay Area. It's crazy how expensive values are. And if you have an assessed value of $300,000, so you've had it for a long time, so a huge gap between the fair market value and the assessed value. If you leave it to your kids and they keep it as a rental, or you leave it to nieces or nephews and they don't live in it, if you don't do Prop 19 planning, the increase in taxes could be $33,000, $34,000 per year. Per year. And even if they live in it, you're talking about a $22,000 or $24,000 property tax increase every year. So I just did some projections, assuming that property taxes go up by 2% a year if a family does Prop 19 planning, working with us, or if they don't. The difference over 10 years for a $3.3 million home, you can adjust it up or down depending on the value of your home or rental property. In 10 years, it can be $360,000 in extra taxes. Over 20 years, $800,000, and over 30 years, we're talking about almost $1.34 million in property taxes paid if people didn't plan for Prop 19 versus if they did. And keep in mind, property taxes, you have to generally pay those with after-tax money. You can only deduct a small portion of that from your federal and state taxes. So really, the difference to your child or children can be, they'd have to earn an extra $2 million to pay this $1.34 million in extra property taxes. So the stakes couldn't be higher, even if you just own one property. So talk to us if you have appreciated real estate or rental properties, so we can at least go through this issue and you can decide if you think it makes sense to plan for it. Let's talk about 5 action items that you should take to make sure that the title for your assets is up to date and that you are well situated to deal with whatever life may throw at you. So 1, you need to review your living trust and power of attorney documents. So if you don't have them, of course, if anybody in your family circle who doesn't have these, they need them. If it's a parent or someone who you're going to have to help out when they're sick or incapacitated, that's going to all fall on you and you're going to have a mess if they don't have it. So make sure that you have an updated living trust, power of attorney. Peace of mind members, we can regularly review that with you. Every year we can take a look. We want to make sure you have the right successor trustees. So however assets are titled, if you have the wrong person named to help you out if you need it, well, it's not going to do you much good. It could still be a mess. We want to make sure your successor trustees and the people named in your power of attorney document are up to date. We probably want to redo at least your power of attorney document every 3 to 5 years, and your living trust, similar updates, because laws change, your situation changes. So let's make sure your living trust, your power of attorney are up to date. Let's review your trust asset schedules. Remember that Schedule A, B, and C. Schedule A, community property assets. B, husband separate property. C, wife separate property. Peace of mind members, we update this with you and for you every year, but it's important to take a fresh look at that. Does it reflect your updated accounts? Is it up to date? Let's make sure it is. And also work with the financial institutions that hold these assets. Talk to them every couple of years. Make sure that those accounts are in your living trust. Non-retirement assets and real estate, let's review title for those. Are they titled, as I kind of mentioned? So non-retirement accounts, investment accounts, they can be on your Schedule A, B, or C, but if they're not titled in your trust, that's a problem. So let's just make sure that whatever accounts you may have opened in the last few years are properly titled in your trust. And your real estate you purchased or bought and sold, let's make sure that your trust schedules are up to date and that anything you own is in your living trust. And we can help with that. So come to us and we can help coordinate all of that. Life insurance and retirement accounts, assets that don't go in your living trust, crucial to take a fresh look at those every couple of years. Make sure your beneficiary designations are up to date. It also relates to item 1, make sure your durable power of attorney is up to date, because the person named in your durable power of attorney is the one who can step in to manage your life insurance and retirement accounts. Again, those aren't in your living trust. Who's authorized to deal with those? The person named in your power of attorney document. So make sure that your power of attorney is up to date and that you've constantly taken a fresh look at the beneficiary designations. You don't want to be stuck leaving it to someone you don't even know anymore, or to a sibling who doesn't need it in lieu of your kids. So take a fresh look at that. And if you've set up trust for your child or children, you need to make sure those trusts are named, or at least maybe redirect it to your living trust, so it goes through the rest of your living trust with the rest of your estate. Trade-offs with all these, we can always chat with you about this. Long-held real estate with low taxes. Yes, I know I've hammered this. just talk to us about this. The stakes are so high. This might be the one biggest lever that we can pull to prevent massive tax increases in your entire estate. So let's just at least be aware of Prop 19. So if you've owned real estate for a long time, in addition to making sure it's titled correctly now, we may want to change that a little bit using some sophisticated techniques that we've developed to protect property tax increases and to make sure you get the stepped up basis when you pass away. So just talk to us. So I hope this is all helpful. Of course, if you haven't followed much, follow our Gilfix Law YouTube channel. If you're watching this online, please comment, ask us questions, like it, share it. But I think mainly don't miss this opportunity. Even Peace of Mind members, you guys know how to find us. Use your annual consultations, meet with us if you're a Peace of Mind member. And if you know anybody in your circle who could benefit from this, very easy to find us, gilfix.com. You can call us at 650-493-8070. I think we have a different number online that also works. But take action, call us, contact us, and we can help. You know, no matter your situation, we can help. It's been a while since you looked. If you don't think there's any changes and you're not sure, come in, let's take a fresh look and just give you some peace of mind. That's what our program is all about. And if you need to make updates, come in and meet with us. And please let anybody in your circle know about these crucial tools, especially if you're going to be on the hook for helping them if and when the time comes. If they don't have an updated estate plan, you're the one that's going to deal with the absolute mess, and their family will. So, title to assets, it's so important to do it right. Let's work together to make sure things are up to date, because little mistakes can cause massive problems. So I will take just a couple of questions now. If you have them, please enter them in the Q&A function. But I really thank everybody for joining me here today. I'm sorry that Mike couldn't join us, but I hope this gets your mind going, that you have some ideas for maybe discussions to have with loved ones. If you've named people in your document, it's been a while since you talked to them. Hey, it's a good excuse to go over some of this, how this all works. If there's any accounts you're not sure if they're properly titled in your trust, hey, we can help with that, but also talk to your financial advisor or make sure that's all up to date. And beneficiary designations for life insurance or retirement accounts, crucial to take a fresh look at that. But let's make sure your estate plan is up to date, that you have all the right tools there. Let's make sure you have protective tools for your kids and grandkids, or if there's someone with special needs in your family who might need that, let's make sure that's all incorporated. And titling assets properly is a huge part of that. So on that note, I'm going to wrap things up in just a second. And I did have one question just about beneficiary designations for life insurance, how that works, how specific you have to be. And actually, I've had people contact us about, if I want to leave a life insurance policy to a special needs trust, how can I be sure it's properly done? If you're not sure how to do it, you can always contact us, and one of our paralegals can help you to make sure that the form is filled out as best we can. Naming trusts can sometimes be a little bit tricky, like an irrevocable special needs trust or family protection trust, but we want to make sure that's done properly. Conversely, you can't always just name your living trust as the beneficiary of an account. So I think on that note, we're probably going to wrap things up, but I thank you for joining me here today. To our Peace of Mind members, thank you so much. We greatly appreciate the community that you're a part of, and we greatly appreciate the opportunity we have to serve your family. So hope you got a lot out of this. I hope everybody's staying safe, sane, and healthy, and we'll see you very soon, and I hope everybody stays well. Take care.